Okay, folks, let's get started. This video topic introduces the legal standards that are going to govern the creation of the lawyer-client relationship. When we meet next time, we're going to apply these standards. Now, once you have an attorney-client relationship in place, all the various lawyer duties kick in, duties to the client that we're going to examine for a big chunk of this semester. But we'll start off with this body of law that talks about when the relationship has begun to form these duties. It happens all the time. A lawyer and a non-lawyer are talking, or maybe they're corresponding, emailing. They're communicating in some way. Hi, I'm a lawyer. Oh, interesting. I have a problem. Oh, tell me about it. Well, here's what happened. At some point along the way in that very normal interchange, the law says, now we have an attorney-client relationship. So we'll be talking about what that legal standard is. So why does this legal rule matter? Well, once the legal standard has been satisfied, there is a fiduciary relationship in place. What do we mean by fiduciary? Well, a fiduciary, as you probably know from other areas of the law, a fiduciary holds something in trust for another. It says, you can trust me. Like we have our loyal creatures here who one is watching the back of the other. You can trust me. You can let your guard down. I won't hurt you. And if I do violate that trust, if I do hurt you, then bad things can happen to me. That's what we mean in general under the law with the law of fiduciaries. Now this trust relationship gets enforced in several different settings. So we have tort suits. So if something goes wrong later on, then a client might sue the attorney and say, you hurt me, it's malpractice, I'm going to have to recover. The actions of the attorney will be measured according to the standards of this fiduciary relationship if the court believes that indeed an attorney-client relationship had been formed. Similarly, for contract purposes, it may affect the measure of damages or the matter of liability in contract law if the court believes that this higher level of fiduciary responsibilities attaches to the lawyer in this relationship. And then finally, the presence of an attorney-client relationship will affect how the bar enforcement authorities react. They will impose these higher obligations on an attorney if there was such a relationship, and that'll affect what kind of discipline, if any, they're going to impose on the attorney. So it gets enforced, this higher relationship gets enforced in several different settings. Now, the relevant legal standard here does not come typically from the professional responsibility rules in a given state. It's generally not defined in any detail in a statute. Instead, this is something that's typically created as a matter of common law. And so if you look at the restatement of the law governing lawyers, section 14, that is a summary of this common law definition of the relationship. Now, the common law standard has two parts. The first part says that you've got to have some person, other than the lawyer, who manifests to the lawyer that person's intent that the lawyer is going to provide legal services. So somebody else comes up to the lawyer and does something, says something that indicates, hey, I think you're about to provide me some kind of legal advice. The second component of the common law standard could be satisfied in one of two ways. So we have a 2A or a 2B. Under 2A, the lawyer just does something or says something to indicate to the other person, yep, I'm going to be providing some kind of legal services to you, legal advice, applying your situation to general standards of law, what have you. It could be words, it could be actions, but in one way or another, the lawyer manifests consent to go forward with this provision of legal services. The other method is even though the lawyer does nothing, says nothing, nevertheless, the lawyer knows or reasonably should know that the person is reasonably relying on the lawyer to provide the services. And that's just a very fact-specific setting. You have lots of common law variations on that theme. But that's the common law standard that you'll encounter in pretty much any jurisdiction. Let's apply this now. An example of this common law standard at work shows up in the Morris versus Margulis and Grant PC case. This is just a big tangled mess. It begins back in 1983 when the law firm Brian Cave represents this fellow Edward Morris in the matter of a will. And in fact, a Brian Cave attorney was named as the executor of the will. And then second, in a domestic relations matter in 1989, they represent Edward Morris. And then in 1990, they help Morris with a severance agreement with an employer. After those earlier representations, Morris, who is the director of a savings and loan called Germania Bank, starts to get in trouble with the government. The SEC starts investigating. You got criminal charges. There's this big criminal investigation, and Edward Morris is one of the possible defendants and targets in this investigation. Now, the government has several different parties in its sights during this investigation of Germania Bank. And so Brian Cave ends up representing several of the other Germania Bank officials during this investigation. And they say to Morris, they explicitly say to him, "We are not representing you in this matter." As it goes along, the clients of Brian Cave, their strategy is blame Morris. We didn't do anything wrong. If somebody was carrying out a fraud at this bank, it was Edward Morris, and so Brian Cave's clients are blaming Morris. And Morris says, "Hey, wait a minute. I object to this. These are my lawyers at Brian Cave who are blaming me." In fact, the Brian Cave lawyers were sitting in the back of the courtroom on the first day of Morris's trial, taking notes and then passing suggested questions along to the prosecutors to help them make Morris look worse. That would, of course, help the Brian Cave clients. And Morris says, this is a fundamental conflict of interest. You have violated your obligations to me. So after all the dust settles from the criminal action and the SEC investigation, Morris sues the lawyers at Brian Cave and says, "You owe me money for violating your fiduciary obligations to me and helping the government in its case against me." Brian, asking for civil damages. Brian Cave's answer, the lawyers at the firm say, "Well, wait a minute. We didn't even have an attorney-client relationship with you for purposes of this matter. For one thing, you had other lawyers. You knew who you were supposed to consult about Germania Bank stuff, and you were talking to them all the time. You had lawyers. And," says Brian Cave, "we told you that we weren't your lawyers. We explicitly said we're not representing you in this Germania Bank matter. And you never confided in us. You never told us any secrets relating to the Germania Bank thing. You never paid us any fees. We never signed a contract. There just was no relationship." The trial court bought this argument and granted summary judgment for Brian Cave. But on appeal, the appellate court in Illinois reverses and says, "No, you're going to have to try this matter and measure damages and decide whether there was a breach of the duty," because a duty did exist. That is, there was an attorney-client relationship here between the law firm Brian Cave and this person, Edward Morris. Now, what were the reasons that the appellate court relied on to conclude that there was in fact an attorney-client relationship here, even though the law firm had disclaimed it? Well, for one thing, there were these prior representations of Morris on personal matters like the will and the employment contract. It's also true that Morris, just in informal settings, occasionally sought advice from Germania about, or from Brian Cave, the law firm, about the Germania Bank situation. And the key thing, they answered. They gave him advice relevant to the workings of Germania Bank every so often. Acta non verba, we say in Latin, or deeds, not words. That's what counts. He asked, they answered. That starts looking like an attorney-client relationship. In addition, a key thing going on here is that Morris's wife, Peggy, Edward Morris's wife, Peggy, is actually a lawyer at Brian Cave. and she's trying to help her husband out along the way. And as she's formulating something called a Wells submission to the SEC, which is a way of presenting evidence and legal theories that the person believes the SEC should consider, she goes to a partner at her firm, John Goebel, and she says, "What does a Wells submission look like? Because I want to help my husband, file his Wells submission." And he gives her an exemplar, and he tells her in general terms what they look like. But then he says, "I'd better not say anything more because we're representing these competing targets of the investigation." So we do have a little bit of help getting indirectly to Edward Morris by way of his wife, Peggy Morris, who's a lawyer at the firm. So putting all of that together, the appellate court says we've got an attorney-client relationship here, and therefore Morris might be able to recover. So to sum up here, there is an attorney-client relationship between the person, Edward Morris, and the law firm, Bryan Cave, even though the lawyers were saying, no, we don't have an attorney-client relationship for this purpose. Nevertheless, they acted somewhat inconsistently with that through giving him casual advice about his business and through giving his wife background information about how to respond to the SEC. So given those actions, a reasonable person would rely on the law firm as having entered into an attorney-client relationship. Certainly the existence of the prior relationship on the wills and the other unrelated matters strengthened the case. It probably wasn't necessary to reach this conclusion, but it made the conclusion more likely. It strengthened the hand of Edward Morris here. So that's an example of the restatement standard being applied. We'll work further with applying this standard when we meet again. Now we've talked about the legal standard that tells you when you actually do have an attorney-client relationship. There are also some settings where a court will say, we don't really have an attorney-client relationship here fully formed, but we have something that's so close that the lawyer owes at least some of the duties to this person that lawyer would owe to a real client. So you could call these almost clients, or I call them quasi-clients, although that's not a term you'll see in the case law. Where do these come up? A few different settings. One of the standards where the lawyer-client relationship is almost present is what both the restatement and the model rules call prospective clients. Lots of times lawyers will meet as an initial matter with somebody who might become a client. You listen to their story, you get an idea of whether you're going to be able to help that person, whether it's worth it to take them on in your practice, and then you decide whether to go forward. But whatever you learn during that initial consultation, you have to keep quiet about. So when we're talking about prospective clients, both the restatement and the model rules say that you have some of the secrecy obligations of a lawyer, even though you never go forward with the attorney-client relationship. For me, the most famous fictional example of this comes from The Sopranos, the wonderful television series where Tony Soprano and Carmela are about to get a divorce, and so Tony immediately goes out and consults with all the high-powered New Jersey divorce lawyers and talks to them about his secrets for 15 or 30-minute initial interviews, and then he never hires them. But then when Carmela comes around later on to hire them as her counsel, they say, "Sorry, I can't take you on because that would be a conflict of interest with somebody who is a prospective client." So just as Tony Soprano manipulates all sources of law, he manipulates the rules of professional responsibility here. There are two other common settings where you may not have a true attorney-client relationship, and yet the attorney owes some part of the duties to that person, just like you would owe to a client. One of the most commonly encountered is a joint criminal defense, where you've got several different co-defendants all facing charges in a single proceeding, different lawyer for each of the defendants, but maybe they get together and compare notes and come up with a joint strategy. In that setting, the attorney for client A might have some secrecy and other loyalty obligations that they owe to client B. Even though the contract and the true relationship is with client A, other defendants in the group get the benefit of some of those obligations. Another setting is in the insurance setting. In some insurance contracts, The company says we will hire the lawyer and the lawyer will be working for us, but you, the insured, have to cooperate with that lawyer. In that setting, the lawyer may owe some type of fiduciary obligation to the insured, even though technically the company is the lawyer. You also see some contracts where it's set up the other way, and the lawyer is designated by contract as the lawyer for the insured, simply being hired by the insurance company. So it can come out either way under the contract, but there is some quasi-client relationship that is often owed in the insurance contract context. You read a complicated example of one of these almost client situations. This involves Westinghouse, which is an electric company, and they had entered long-term uranium supply contracts under the UCC, and then they breached those contracts, or at least they no longer were carrying out their terms, and so the uranium firms were suing for breach of contract. The law firm Kirkland & Ellis is representing Westinghouse here, the purchasers of the uranium, and one of their defenses is that the uranium industry is overly concentrated, too few firms selling the uranium, and it's an antitrust violation, and so our contract breach is okay here because you were in breach of the antitrust laws. So Kirkland & Ellis is making this argument on behalf of Westinghouse. Meanwhile, the energy supply companies like Kerr-McGee and Getty and Gulf, they say, we can get rid of we can knock out the favorite counsel, the lawyers for Westinghouse, because we can claim that they used to be our lawyers and there's now a conflict of interest. And this is one way that you can get rid of lawyers you don't like on the other side. And so they claim that Kirkland & Ellis represented us, and in fact is representing us in another energy industry matter, and the district court disagreed, but again the Court of Appeals said, yeah, we think there was something close enough to an attorney-client relationship in that other matter that there now is a conflict of interest, and we're going to have to somehow remedy that. It's a complicated remedy, and we don't have to talk about that now, but the almost client relationship is there, and we have to account for conflicts of interest because of it. Now, what was it that Kirkland & Ellis lawyers did that created that almost client relationship with the energy supply companies? Well, they actually represented the American Petroleum Institute, API, which is a trade group. They didn't literally represent Getty and Gulf and Kerr-McGee, but Getty, Gulf, and Kerr-McGee were all cooperating members of the trade association. They paid the dues and benefited from the activities of the trade association. And as the lawyers from Kerr-McGee, from Kirkland & Ellis were going around trying to help the API put together a report for Congress, trying to convince them not to further regulate the energy industry, they interviewed these various members of the API and got important information from them about how the industry operated. And so Kerr-McGee, Getty, and Gulf all say, well, maybe Kirkland & Ellis were representing technically the trade association, not us, but boy, we had an interview and they were asking us confidential information, and we cooperated, and it was almost like a client relationship. And the Seventh Circuit agreed here and said, yeah, that's enough to create a conflict of interest. We've got to remedy that. So there's an example of one of these almost conflict situations. Okay, so you've seen the common law restatement standard at work. You've seen it defined and a little bit applied in at least one case. And you've also seen how the same fiduciary obligations, at least a subset of them, sometime apply even when the standard hasn't quite been met, but somebody qualifies as a prospective client or some other kind of almost client. We'll practice applying these concepts when we get together next time. See you then.